Hi everyone, I'm David Glazer, and I'm here with Briar Andreessen, who's too far from the phone to yell. And we're here to talk about some creative approaches for interacting with or avoiding the government. Before we jump into this, just the general housekeeping announcements. First, important one, the internet sometimes slows down over the noon hour. You can always use the dial-in number that Robert is sending out if the sound starts to sound crummy. The odds are if it starts to break up, that's an internet issue and not anything kind of on either of our two ends. So use the dial-in number. Hopefully you saw this actually is not going to be the usual 1 hour session. We're going to go 90 minutes, and we're going to be talking really quickly because we've got a lot of stuff. I'll be doing actually the bulk of this, and then Briar is going to pick up shortly after, about an hour from now, to talk about the HIPAA part of things. So I'll get us going, and then Briar is going to do about 15 minutes on HIPAA, and then I'll wrap us up. And then the last point is our next webinar on November 9th is going to be about relationships in the healthcare industry. And a couple of our colleagues who are way more creative than I am have come up with neat ideas on how to do sort of joint ventures, acquisitions of physician groups. We're clearly entering a phase of rapid consolidation, and we've got some interesting ideas on neat ways you can make that happen, and that will be the topic on the 9th. Okay, so our agenda today, we're going to talk a little about the refund requirement, internal reviews. I'm going to walk through many situations where people think there's an overpayment, but there's not. Talk about tips for how you can make a voluntary disclosure without stepping in it. That'll go for collectively about an hour. Then Briar's going to do some stuff about HIPAA, and then we'll talk about how do you prepare for investigators. Just an organizational point for those of, if you're better organized than the title of this is Interacting with the Government, but an internal investigation is really an interaction with the government. And so in many ways, what you do internally has a big impact on what happens externally, as illustrated by the fool. He's on the keyboard. It's very easy to accidentally climb out of your fishbowl with your internal review and have your internal review be something that gets you into trouble. A core principle that I hope all organizations will go with is that you should treat the government fairly and require them to treat you fairly. It's reasonable for you to get paid for what you do unless the government has issued a clear rule prohibiting it. And I think the duty on all in the healthcare industry is if you've been overpaid, you've got to refund the money. What troubles me is that in the healthcare industry right now, I think mistakes are regularly characterized as fraud. And the government sort of speaks out of both sides of its mouth here. If you read a quote from Eric Holder, who's now the Attorney General, but was then the Deputy Attorney General, about 11 years ago, he made a talk where he was presenting to the American Hospital Association and said, the False Claims Act should not address, and we should never use it to pursue honest billing mistakes or mere inadvertence. And that sounds really good. And I think everyone on this call can probably think of at least one example of a situation where the government hasn't lived up to its word in this regard. In fact, in my mind, as healthcare organizations, you are this. You're a car with all kinds of stuff like a laptop in it, and the government is this guy. And he's looking in the car to see what he can get by going through your car. And really, I think the theme of this speech is, I want you to lock the car doors, because I think that if the government has to break the window to come in, they're less likely to do it. If you leave the doors unlocked, they will come take your laptop computer, or in the case of this car with the keys in the ignition, just take the whole car. And so what we're going to try and do is talk about how you make sure your laptop stays in the car, which actually ties in with HIPAA, as for Briar. Okay, so questioning authority is a fundamental principle that you have to go with in the healthcare world right now. If someone comes in and says that this is a requirement, you have to figure out if it's really a requirement or if it's just a guideline. For Medicare, that hierarchy is really clear. You're looking for whether it's in the statute, whether it's in the regulations, or in the manuals. If someone insists it's a rule, make them give you a copy of the rule in writing. But I think the toughest thing is that just because someone can show you the rule in writing doesn't really mean the rule is valid. And that's where, as a legal team, we really become key, is being able to demonstrate that the rule was properly promulgated. Just because someone sounds smart doesn't mean they know what they're talking about. Relax, Worthington, as the warm, moist air from the jungle enters the cave. The cool, denser air inside forces it to rise, resulting in turbulence that sounds not unlike heavy breathing. Well, here's a good example of the fact that just because someone sounds smart doesn't mean that they're right. A lot of MACs, and right now CMS, will tell you that you can't charge a Medicare patient interest. And the authority that they cite for this premise is a regulation that allows you to only collect the difference between the Medicare approved amount and the Medicare payment, which is like any copays and deductibles and things like that. And CMS has said, so you can't charge interest because all you can collect is the copayments and deductibles. That sounds really authoritative until you give it some thought, and really, unless you're aware of a medical learning network memo that came out that talked about the ability to charge patients for a missed appointment. And it said, hey, a missed appointment isn't a service, it's a charge for a missed business opportunity, and therefore you can charge patients for missing an appointment. Well, that same logic would apply to interest. And since that's, basically it's quite clear to me that you should be able to charge interest. I wrote a letter to CMS after they complained to one of our clients, and they said that our client couldn't charge for interest, and they ordered the client to refund all of the money. I wrote CMS a letter and said, no, we're not refunding the money. They did agree to stop charging interest going forward, but said legally you can't come after them because of this medical learning network memo. Well, that letter's never been answered, and the client hasn't been attacked. And I think that there's a lesson here, and it's a principle, which is just because someone can point to a regulation to support their principle doesn't mean you have to cave with it. So the next chunk of this speech is going to be talking about some examples of that principle. So first, I'm sure most of you know by now that healthcare reform set up a new requirement to report and return any overpayment within 60 days of the identification of that overpayment. And this sets up two big questions. What's an overpayment, and when is it identified? So really the question is, when does that 60-day clock start running? And I think the answer to that is really clear. The 60-day clock does not start running the minute you get a call from someone who says, I think we have an overpayment. In fact, that 60-day clock doesn't even start running when someone calls and says, I know we have an overpayment. Instead, it starts to run when you know the amount of the overpayment. So how do I know this? Well, you have to look at the statute. And the statute creates a duty to report and return an overpayment. Well, you can't return an unquantified amount. So that's the first part of this argument, is obviously until you have specified the amount of the overpayment, you can't possibly return it. But there's additional backup if you look at the legislative history of this bill. So identification isn't defined in the law itself, but there was a House bill that was proposed. The Senate bill is what was finalized. The House bill required reporting when you know of an overpayment. Well, that to me would be the 60-day clock running when someone picks up the phone and says, I know we've got an overpayment. That wasn't what Congress actually passed. They instead said you have 60 days from when you identify an overpayment. And I don't think you can have identification without quantification. And I feel quite strongly on this. CMS has said that they're going to issue rules to clarify it, and we'll see what happens. Pending those rules, however, I don't think you have any duty to start running your clock at the first whiff of a problem. I think you can wait until you have quantified it, as long as you work in good faith. So the next question is, what is an overpayment? And the law defines it as funds that you've received or retained under Medicare or Medicaid, so this doesn't apply to private payers, to which the person, after applicable reconciliation, is not entitled to under the law. So a couple of things. First off, to me, the applicable reconciliation means you get to offset any underpayments. So when you're dealing with the government, offset underpayments, whether you're making a voluntary disclosure or fighting against one of their assessed overpayments, and I think that's kosher. But the next thing is that many regulatory violations aren't overpayments, and we're going to talk about the first two of these in detail, poor documentation and violations of the conditions of participation. I'm not going to talk about reassignment problems in detail, but I will just toss out there, if I bill for a service that was performed by Breyer, that's a violation of the reassignment rules, and the government can take away my ability to accept assignment, but they do not have the ability to take the money back. And I can back that one up if you want to know. All right, so next I'm going to talk a little bit about internal reviews and sort of the prep work. So what do you do to prevent a government audit. And that's a trick question. You can't prevent a government audit, especially if you have any anomalies. And so I'm a big fan of recognizing anomalies. Anomalies are inevitable. And really what you need to do is think like an auditor and anticipate problems and try to adjust before they happen. And if there were only one piece of data that I could get as an auditor, it would be productivity data. And the reason I say that is I would look for work that seems to be being done at an impossible level. A physician who's producing more than the physician can produce in the amount of time. So that's the one piece of data I'd go with. There are other things, obviously, you do look at. You can look at documentation, look at variations in coding distribution patterns, variations from the norm, variation from practitioner to practitioner or from site to site. Obviously you're going to look at what internal employees report about being nervous about, but the one thing I'd really focus on is production. If you've got physicians, you should clearly be looking at graphs like this. And note that, there's that one doctor who codes everything as a 99204. That doesn't mean that the doctor is coding improperly. It just means you want to make sure that this doctor understands what a 99204 entails. But that's an illustration. Just because someone is anomalous doesn't mean they're wrong, but the doctor who's up there doing all of his or her codes at 100% is highly likely to be audited. So just look at them and figure out what's up. Part of what you can do to minimize your risk of interacting with the government is making sure you have an internal process that works well. On both the hospital and the clinic side, someone's got to be looking at your charge ticket. And if you think there's the University of Chicago case a few years back where this was on the physician side, their charge ticket didn't have the lowest level codes. And that funneled people to use the higher level codes. So part of your process review is figuring out what internal bureaucratic mechanisms make it difficult for people to bill accurately. And that can be hard to think about. You have to think kind of creatively. You also want to to me, part of being a good lawyer in this stuff is keeping your eyes peeled. If you're in someone's office, look, if their CPT book is 3 years old, that's a problem. Do they have the current copies of the manuals? And are they looking at stuff like that? And just to eavesdrop to what's going on around you and listen to how people are handling problems. If someone's on the phone with a person who's raising a concern, does the person handling the call express sympathy and listen to what's being said, or do they push back and disbelieve the reporter of the problem? Okay, compliance plans will get put to the test whenever you interact with the government these days. Whether you are voluntarily disclosing a problem or they're coming to you, a common question from the OIG right now is, what's your compliance process? And how many reports are you getting on your hotline? What other refunds have you made? So you want to make sure that you're tracking that stuff on a regular basis. I also strongly encourage you to at least annually, or maybe even better yet, semi-annually, no matter how big your organization is, ask all of your employees to report their concerns and to put them in writing. And I've got a certification that I'm happy to send you. Send me an email and we'll just whip that thing out. It's short. It's a pain in the butt when you send it out because you'll get lots of stuff back, but it can really help you identify problems, and it can also help you avoid the situation where someone claims to have reported a concern for years and years and years, and you can show the certificates where they, in fact, haven't reported the concern. So if you're doing an internal investigation, one of the big questions that you're going to have to think about is who should do it. I am a big fan of having investigations done by someone that's not the lawyer, if you can help it, because it's cheaper, but you have to recognize the cost that goes with that, and there are a couple. So one question is, who are people going to be candid with? Is it an insider or an outsider who's going to be most effective at getting information out of people? Who's going to be skeptical enough to really push and ask questions? Clearly, whenever you're doing an investigation, you need at least 2 people. That's just kind of a witness interviewing 101. But if you don't use lawyers to do this process, you just have to recognize, and I bet most of the people on this call understand, the work product privilege, which only applies when work is done in anticipation of litigation. So if it's an internal review, there's a real risk that interviews that are done by non-lawyers might be ultimately discoverable. You have to know it. There's not yet a really clear body of law as to what constitutes in anticipation of litigation. It's unclear if the expectation that you're going to make a voluntary disclosure to the government is in anticipation of litigation. If you've got any doubts about that, the lawyer should be doing the internal investigation. One part of avoiding interacting with the government is making sure that any consultants you hire are on your side. We've had a number of horror stories where we've hired a consultant and the consultant thought that his or her job was to turn the client in. So one trick for avoiding interactions with the government is to make sure that before you bring in an outsider, you've checked out their references. Make sure that they're really on your side. Now, another place that things can go to the government without your control or authority is obviously from whistleblowers, from qui tam people. And one of the questions you have to deal with as a lawyer is, should we be making our employees waive their right to bring a qui tam case? And I think most of you know you can't really do that. It's not effective. It's the problem of this sign. Notice you must be as tall as the city to attack the city. You can't bind someone to a promise not to go to the government. But there is something you might be able to do. In a release between a departing employee and your organization, it does look like it's valid to have something in there where the employee or ex-employee waives their right to get the relator's share of the proceeds of any qui tam case. So that wouldn't prevent them from going to the government and reporting something, but it would prevent them from reaping a financial reward. And there does appear, there's at least one case, I think it was in the Fifth Circuit, and I apologize for not putting a citation in here, which supports the idea that you can have employees waive their right to a qui tam settlement. So that's something to think about. All right, I now want to go through about 5 scenarios that are common situations where people think that they have an overpayment. And I want to give my legal analysis as to whether I think you have an overpayment. And then after that, we'll talk about, if you do have an overpayment, how you deal with that. So the first one, and this, many of you may have heard me do this talk before, but this is the perhaps most common overpayment situation out there right now, crummy documentation, in this case on the physician side of things. So you have an internal audit, we'll put that in quotes, that finds, Dr. A was doing okay. Dr. B is overcoding 20% of her charts. Dr. C's got 35% overcoded, and Dr. D has 81% overcoded. And you have to figure out, what are you going to do with this? Well, it's important to recognize that the law is not, if it isn't written, it wasn't done. That's great risk management advice, but a documentation deficiency by itself doesn't create an overpayment, with a couple of little asterisks next to it. First asterisk, this only applies to Medicare. If you've got a private contract with Blue Cross Blue Shield, it often might require documentation. Medicaid in your state might require documentation, but Medicare does not. The documentation guidelines are just that, and Medicare seems to be reluctant to believe it, but it's really clear. How do we know it's really clear? Well, let's look at the law. The law says that you can't make payment to any provider of services unless there has been furnished the information that's necessary to determine the amounts due the provider. Now, note that there's no reference to where that information has to be furnished. It doesn't say it has to be in the medical record. It doesn't say it has to be written. So you can furnish that information in a letter. You can furnish it telephonically, in testimony. You can furnish it any way that supports that you provided the service. It could be testimony from a patient. So a lack of documentation doesn't automatically create an overpayment. It instead creates a question as to whether the service was properly provided. Further backup from this appears in the CPT assistant. The CPT assistant, back when the documentation guidelines first came out in 1995, 16 years ago, said that the guidelines aren't a law. Physicians don't have to modify their record-keeping practices at all. And then CMS put out a question and answer sheet. And I don't think you can find this anywhere on the web, but I have it and I'd be happy to send it to you. This question and answer sheet, and I owe a huge debt of gratitude to Leon Raby, who was a person who understands Medicare rules really well and who found this document. The question was, are the guidelines required? And the answer, you can see I've put it in orange, was no. I'm not going to read through the rest of the excerpts of this document in gory detail, except to note a few things. So Medicare carriers are supposed to use the guidelines to verify that the services reported were actually rendered. If the documentation doesn't support the level of service provided, the carrier is supposed to contact the physician for additional detail. Here's the principle. Documentation provides evidence as to whether you really did the work. If you really did the work, you should be paid for it. And ultimately, in a documentation review, that's the test that I think you can and should use. So if you, that's really the test. Here's a side note, and actually in some ways this should be a signed note, and we're going to talk about this one in a minute. This same question and answer sheet talks about physician signatures, so more on that in a moment. But let's return to our internal review. All right, so if you look at this internal review, what are you going to do with it? Well, I think you're going to ask a question, which of these services do we think were really done? Now, how are you going to figure that out? Well, you're going to have to ask. You're going to have to ask the doctors, did you do stuff that wasn't done? You're going to start thinking about other ways to solve this problem. Once again, I think the single most important or useful piece of data is production data. I'm going to try to figure out, if we look at Dr. D, he doesn't have documentation on 81% of his claims, but let's look at his RVUs and whether we believe that work was done. We're going to look at patient schedules. You might, on the basis of time, be able to get a sense that, we had patients scheduled for 8 hours. If you took the time element of the 99213s and added them up, that shows about 8 hours of interaction. Well, that's further support that the service was provided. You're not supposed to use time on an E&M basis if it wasn't counseling and coordinating care, but it can be a useful thing to back up the idea that the work was done. I've had clients use secret shoppers who have gone in, kind of use a fake patient, as it were, to have the patient examined by the doctor, look at what the doctor wrote down and see if there are documentation deficiencies, because if the doctor does stuff that he or she doesn't write down, that further supports the notion that the work was really done. I want to highlight something I've said many times before, but avoid using the word audit if humanly possible. The government seizes on it to suggest that you need to refund the money. And I also hate the terms overcoded and undercoded. I much prefer to characterize things as documentation does or does not support the code build. I think that word choice is very important because you don't know if the documentation is present, that doesn't prove the work was done. We've seen a number of situations now, especially in the electronic medical record, where you have great documentation of an encounter and it doesn't prove, but that doesn't mean that the encounter happened as it was documented, just as the absence of documentation doesn't prove it didn't. All you know when you've got documentation is whether that documentation meets the code. You don't know about over and undercoding. So in our case, if you did a little bit of digging, let's just say in our hypothetical, Dr. D, who remember has 81% of his codes overcoded, is a super hard worker, but he's only at the 75th percentile for RVUs. But he's there more than everyone else. He doesn't take vacations, so he's the hardest worker we've got, but his production data is sort of in the middle. It's not in the middle of the bell curve. It's at the upper end, but in a believable place. I'm okay with Dr. D. Dr. C, who looked better if we go back here and look, Dr. C was only overcoded on 35%, or should we say his documentation failed on 35%, so way better than Dr. D. And he's a hard worker, but his RVUs are twice the 90th percentile. So I'm really worried about Dr. C. And so I think the lesson there is that this chart alone doesn't tell you enough. You need to compare it to other data. So where would that leave me? I'm okay with Dr. D. I think that I believe he did the work. I'm not going to do any refund. I'm not going to have any interaction with the government. This is one where I'm avoiding interaction with the government. Dr. D, I'm going to need to do more development because I'm worried about Dr. C. I think I misspoke, but Dr. C is the one I'm more worried about. So if you conclude the work wasn't done, what are you going to do? Well, then I think you've got to refund the money. And one of the questions you're going to do is, how much should you refund? And some people are going to think, well, here's what we'll do. We'll do a refund of Dr. C's claims. We'll do some kind of sample. Well, a sample isn't going to tell you anything, actually, because we already know if you go back to Dr. C's data, I can tell you what's going to happen in the sample. 35% of them are going to have improper documentation, or actually 50% of them are, but 15% are going to be underpaid. What you really need to do is try to figure out what Dr. C really did. So no sampling is going to happen here. Instead, we're going to try to figure out, by using the production data, how much we think Dr. C billed for that he didn't do. And I think ultimately you're going to say, here's what we think Dr. C's production reasonably should have been, here's what it actually was, and refund the difference. That's how I would handle that sort of situation. And if there are questions about that, we can talk about it. Whenever you're doing a review like this, you're going to have to deal with a fundamental question. Should you quantify exposure? And if you don't quantify exposure, you run the risk of failing to get the attention of people who need to listen to you. But if you do, the government may seize on whatever number you use to use it against you. So when you do internal reviews, I encourage you to steal the materials from slides 46 and 47. Just take this language, use it. And it basically says, hey, look, this chart review only looks at the documentation. And that's what Medicare does. We're not trying to figure out whether or not the work was really done. We're just figuring out whether the documentation supports the claim. Steal this language, it's yours. Okay, next scenario. You're in a hospital and you discover that you've got a bunch of unsigned medical records, and you know this violates the conditions of participation. Do you have to refund the money? And it's quite clear that if you violate the conditions of participation, there's a regulation up on the screen right now that basically says if you violate a conditions of participation, Medicare has the ability to throw you out of the Medicare program. But that doesn't tell you whether or not the money is owed back. Whether or not the money is owed back is answered by part of the Program Integrity Manual, and in particular, this language. If during a review, it's determined that a provider doesn't comply with the conditions of participation, don't deny payment solely for this reason. Well, there's our answer. Failure to meet a condition of participation doesn't create an overpayment, and so you don't need to refund the money. So if you're in a hospital setting and you've got some condition of participation that you fail to meet, that doesn't mean you need to refund the money. In fact, I don't know of any duty it creates for you to contact the government at all. You can have a duty to fix the thing, but you don't have a duty to disclose. And so this is another place where the creative answer for interacting with the government is don't fix your problem. So bottom line, actually, I'm going to jump ahead to one more point. Like, let's say that this physician, or the failure occurred on the Part B side. That question and answer sheet we were talking about for evaluation and management claims has the following question. Is the doctor's signature required on every page of the documentation? And the answer is no. And then finally, last piece of backup is part of the Program Integrity Manual, which explains that if a signature is missing from an order and a MAC is doing an audit, they should disregard the order. I have some issues with that on a legal side. I'll put those aside for right now, but just say that if you do have missing signatures on an order, I think that there are ways you can even fight that. But the manual explains if the signature is missing from any other medical documentation, the MAC should accept an attestation from the author of the medical record authenticating its veracity, its authenticity. So it's quite clear a signature alone doesn't create an overpayment. The next example I'm going to go with is one that relatively few people on this call will have happen to them. It's only going to apply to teaching physician. Well, we'll have a mix, but it only applies if you're a teaching physician. But I don't want to focus on this particular example, but more on the gestalt. And the gestalt here is, what do you do when there's a dispute between the regulations and the manual? So the situation that happened here is you have a teaching hospital, and the doctor was working with residents on 3 cases. There's manual language that says if a teaching physician is working on 3 cases, the teaching physician can't bill for his or her work. Okay, and that's pretty clear in the manual. And here's the language right there out of the manual. It's basically, if you've got 3 concurrent procedures, the supervising doctor's work isn't payable. Well, it turns out that the language in the manuals is inconsistent with language that's in the regulations. And this is where things get interesting. I went to court a couple of years ago and lost. And it's not often that you're happy when you lose a case. But this was a situation where I can't say I was totally happy, but I didn't mind. And the reason I didn't mind is I was representing a hospital that had relied on language in a manual. And the government said that the manual was invalid. In fact, what the government said in their brief is if the manuals go counter to the governing statutes or regulation, you rely on them at your peril. So, in other words, don't believe what we say in our manuals. Well, the court agreed, and it said the manuals aren't binding, regulations trump them. It was bad for my client in this particular case, but it helps articulate a principle that can come in really handy if you've got a potential overpayment based on something that's in the manuals. If you can construct an argument based on the regulations that the manual is wrong, I don't think you have any duty to refund the money or notify the government because there isn't an overpayment. And so this is these are 2 statements from the government about their view of the manuals. They're not accorded weight in the adjudicatory process. Take the government at its word. So in this case, the manual said a teaching physician isn't required to be present during the opening and closing of the surgical field. And in the case that we were dealing with here, this was a $15 million question or something like that. It was a really big deal because there were a whole bunch of times where a teaching physician was present in a key portion of one surgery, but not the open and close of another. So focus on the regulations, not the manuals. All right. Next example I want to go through, this one is going to be super quick. Medical necessity denials. They're a dime a dozen. They happen all the time. When you're dealing with a medical necessity denial, you will want to use what is referred to as the treating physician rule. And this is a principle that comes out of Medicare's legislative history. And it's a really great principle that basically, in a close case, defer to the judgment of the physician. And I've just got a couple of cases here. I'm not going to read through the quotes because you can see them in the materials. But the idea is the treating physician's opinion gets extra weight in the Medicare review process. And it's worth noting that there's language in the Medicare manuals, those same manuals that I just said aren't binding, but that manual language says that Medicare shouldn't recoup an overpayment in a medical necessity case if the situation is ambiguous enough that Medicare has to get a physician reviewer to examine whether the services are covered or not. And so this is a really interesting point. You might even want to circle this one on your slides. If you're in a medical necessity dispute and the carrier has used a physician to do the review, this can be an argument that no overpayment exists. So when dealing with the government, in a government-led overpayment case, this can become a really effective shield to fight back against in a medical necessity case. Okay, the next scenario I want to talk about is probably the one I hate the most because it's the one where I feel often ineffective as a lawyer because I can't get to a result that's fair. And this is the old unsigned medical director agreement or the unsigned lease or an unsigned document between a physician group and a hospital. So in this case, the hospital's paid cardiologist as a medical director for the last 5 years and no one can find a signed agreement. And everyone agrees that the work was done. So this is an ugly fact scenario because of Stark. We now have a compensation arrangement that under Stark needs to be in writing, unless there's one saving grace. And I gotta take my hat off to Steve Beck, our colleague, who is super creative and came up with this argument. If you can recharacterize this situation such that the physician was really an employee of the hospital, employment agreements don't have to be written. So if you can recharacterize this situation as employment, I guess recharacterize is the wrong word. If it can properly be characterized as employment, I think your problem is solved. If not, now we think we have a stark problem, and I think we're going to have to deal with it, and you're going to have to do a disclosure. But it raises the question of who do you disclose to, or to whom, I guess, do you disclose, to be grammatically correct. Personally, I am a big fan of the least, you disclose to the lowest organization on the totem pole you can. So of the choices here, if the amount of money isn't huge, I'm just going to write a check and refund to my Mac. If the amount of money is huge, things are more complicated, and then I probably would use the OIG self-disclosure protocol, because that gives you a mechanism to ask the Office of Inspector General to be a little lenient with you if the penalty doesn't fit the crime. And since in this case all of the referrals from the quote offending unquote cardiologists are an overpayment, that's a huge sum of money. You may need the disclosure. You may need to do that. I would only go personally to the U.S. Attorney's Office if I knew that person really well and thought they were going to be really, 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 really nice to me. I don't find myself wanting to get someone who can put me in jail involved in overpayment cases unless I can absolutely avoid it. Now, if you're representing the clinic in this scenario, it's important to keep in mind that the clinic hasn't been overpaid. At most, or worst, the physicians caused improper claims to be submitted. So I don't think the doctor has any duty to do anything. This is a situation where the hospital has a duty, but the clinic doesn't. And so you always have to figure out where your duty comes from before you're contacting the government. So if I'm the clinic, I'm going to try to just sit tight. Okay, my next and I think last scenario involves short hospital stays. And this is one that comes up quite a bit. So you're doing an internal review and you discover you had a bunch of patients who were hospitalized but were in for less than 24 hours. The kyphoplasty investigation on a national level is one illustration of this. So the compliance staff start to investigate and they say, geez, we think we might need to refund all these stays less than 24 hours. Well, I don't agree. And the reason I don't agree is back to the manuals. Here's how the manuals characterize who's an inpatient. So the first thing they say is that generally, a patient is an inpatient if they're formally admitted with the expectation he or she will remain at least overnight. So there's our first standard. If you go forward 2 more sentences, there's the next sentence in orange. Physicians should use a 24-hour period as their benchmark. They should admit patients who are expected to need hospital care for 24 hours or more. Well, that's a totally different standard. A minute ago it was if you're going to spend the night, you're an inpatient. Now it's if you're going to spend more than 24 hours, you're an inpatient. Then we come to the green text. The decision to admit a patient is complex and can be made only after a number of factors, including medical history, current needs, and a bunch of other stuff that it doesn't explain how you calculate. Well, speaking as a lawyer, I now think we've got, in the course of 4 sentences, 3 different standards articulated as to what makes someone an inpatient. We've got overnight, 24 hours, and it's really complicated. I don't know how to operationalize that, and so I don't think an overpayment is created simply because someone has spent less than 24 hours in the hospital. And I feel like there's a really strong legal basis to fight this. Now, I'm going to use this one as an example because this was a situation where I had a client that wanted to be conservative. And as you can tell, I'm a little aggressive in how I approach some of these, and the client wanted to take a cautious approach and refund the money. So I said, okay, you can do that. Refund the money, but no strong legal defenses exist. But this is where we move into the next area, which is how you do refunds, how you interact with the government, and how you don't make things worse by choosing to voluntarily refund money. And so I want to work through those issues. So for example, one of the problems the client had here is they had a new electronic medical record. And so they wanted to do a sample, but the EMR only went back 18 months. And they wanted to do a refund back over a 3-year period. So they were going to look at a sample for 18 months and try to refund for 3 years. Well, that is, in my mind, going to create all kinds of problems. So first, big picture. I think as a lawyer for an organization, our job is a lot like the mouse in this cartoon. Heaven knows what it is or where it came from. Just get rid of it, but save that cheese first. We want to save the cheese, but without getting snapped. And as a lawyer, the job is to figure out, can you keep the money without getting in trouble? Many of you, I'm sure, have heard that foolish consistency is the hobgoblin of small minds. Well, that is true, but so is foolish inconsistency. And one of the things that worries me is that I see a lot of people who are refunding money to the government using standards that if the government used when seeking the money back, you'd think were unfair or mean. And so, in a concrete example, would you feel okay if the government used a sample looking only at claims from 2010 to collect money back 4 years? No, because you'd say 2010 doesn't tell us what happened in 2008. Your sample has to look at all of the years at issue. So you can't refund money using a claim from data from 1 year and then complain if the government does the same thing to you. And so consistency in your approach becomes really, really important. So let's look at when you need to refund money and how you do it in a way that's going to be defensible. So one question I get asked a lot is, at what point do you need to extrapolate? There's a November 20th, 2001 letter from Janet Rehnquist, who was Chief Justice Rehnquist's daughter and was the Inspector General, head of the Office of Inspector General. In that letter, she said that if an organization was part of a corporate integrity agreement, they don't need to they don't need to do a statistically valid sample if they find an error rate that's below 5%. That's the only guidance I'm personally aware of that gets to when you need to extrapolate. And I don't think that that guidance is of perfect applicability to most organizations because it was written for people who are subject to a corporate integrity agreement. And, you know, I don't think anyone on this phone call is. So when do you have to extrapolate? I don't personally know. I know if it's below 5%, I don't think you need to. If you're at 10%, do you need to? I think the jury is out on that, and I think reasonable people could differ. You know, cautious organizations may choose to. Would I feel comfortable saying we're going to pick 10% as the error rate where we're going to extrapolate? I would. Could I point to any foundation for that? I couldn't. All right, you want to try and identify your sample, or try and identify an overpayment. Who should do the sample? This is tough because statisticians are really, really, really expensive. Which gets to the question of, do you want to use Medicare's methodology? My short answer to that is no, but then how do I avoid being inconsistent? Well, here's what I would do. I would pick a method that's cheap, but that's probably over-inclusive, at least for small refund amounts. Intentionally over-refund. If you intentionally over-refund, you can then say in your letter, look, we're not using a perfect method here, but we're giving you more money than you think you're entitled to. And then I think you're not subject to question about cutting the corners, and it still allows you to challenge the government if they cut corners with you. But when looking at a sample, whether it's one you do or one done by the government, you know, the kinds of things you have to think about are the sampling unit. So, you know, are you looking at claims? And, is it a claim line? Is it the whole claim or a particular line? The size? But one of the biggest things you have to look at is precision. And I'm not a statistician. I have a hard time articulating some of this stuff, but I know many statisticians will say that if your precision is below, well, let's make it above. If your precision is above 0.1, your sample is imprecise. By contrast, the Office of Inspector General will let a sample have a precision of up to 0.25 before they will reject it. And so, you know, the OIG will tolerate a lower level of precision, and this is confusing, but a higher number there is a lower level of precision than many statisticians will. So do you want to pick the small number of 0.1, which will get you a broader confidence interval, or do you want to pick the higher number of 0.25? I personally would go with the 0.1, but when making choices like that, you need to recognize the government is going to probably say that a precision level of 0.25 is appropriate. When you're doing a sample, you have to figure out, are you refunding at the midpoint or at the lower bound of the confidence interval? And this is maybe a good place where you can differentiate between how the government handles things and you do. The government is supposed to go to the lower bound of the 90th the 90% confidence interval. If you pick a midpoint, you're refunding a higher number than the government would looking at the same issue. If you're doing a sample, you have to deal with all kinds of logistical issues. Let's say you're looking at 4 years worth of data. Are you going to try to account for the fact that the fee schedule may have changed in each of these various 4 years? When you're picking your universe of claims, are you going to do separate samples for each payer? Are you going to look at Medicare differently than you're going to look at Blue Cross Blue Shield, differently than you're going to look at Medicaid? These sort of operational things are a huge headache and obviously can make things very difficult. You can't have 5 samples on this, and it's what makes these voluntary refunds very difficult. I don't have lots of solid advice other than I would, especially if it's a small dollar amount, try to keep things general, easy to calculate, and come up with a rationale where you can say you think that the actual number involved is smaller than what you're refunding, and so what you're doing is kind of, in quote, close enough for government work. Can you look at 1 year's worth of claims and project back to 3? Generally, you can't, but if that's the only data that's available to you, then you use what you've got and you explain that you come up with a reason why you think that you're over refunding. How far back do you go? Well, that's a little easier. There's at least clear guidance. You're going to go back as far as either there's a factual break that causes you to say there can't have been an overpayment further back in time, or the statute of limitations. Now, for false claims, there's a 6-year statute of limitations that can go back up to 10 if the government wasn't aware of a situation. That, in my mind, is not the statute of limitations you're ever using for a voluntary disclosure. And if the government comes after you, I'm not willingly using that one because I'm going to argue that what we have is a mistake. And if you have a mistake, it's a different standard. And we'll talk about it in a minute, what it is. It's important also to keep in mind that if you are without fault, the government is supposed to waive recovery entirely, and we'll come back to that in a minute. So how far back do you go? There are 2 different tests that apply. One is statutory, and this one is extremely difficult to operationalize, and it only applies in cases involving medical necessity. But a medical necessity case presumes that you're without fault 3 years after the year in which payment was made. And what makes this hard, this has nothing to do with the year in which service was provided, it's when payment was made. So if a service was provided in December of 2003, and the claim is paid in February of 2004, the government can recover money for 3 years after 2004. So through all of 2005, all of 2006, and all of 2007. And so the end of that recovery window is December 31st, 2007. Note that if the service was paid on December 31st, 2004, same cutoff date. Also note that if the payment had been quick, if the payment had been made December 31st, 2003, even though payment is now just a month earlier, you're going to lop a whole year off of the recovery. So that's kind of nice, really hard to operationalize, which was why, from a practical standpoint, I think most people prefer to use stuff out of the manuals. Remember those same manuals that I say aren't binding as the law, that say the government can only go back 48 months unless you're guilty of fraud or similar fault. So from a practical standpoint, this is an area where I think I'm less aggressive than you could be. I usually use the 48 months rather than the 3 years after the year in which payment was made, just because it's operationally easier. The government should only be able to go back more than 48 months if there's fraud or similar fault. Which brings us to a question of, anytime you're in a potential overpayment situation, is there someone you can blame? Because if there's someone you can blame, that might get you out of the overpayment entirely. If you're a hospital and you have an independent medical staff, you might say, hey, look, we didn't make the decision to admit this patient to the hospital, the doctor did. And since the doctor, who we have no control over, made that decision, we're without fault. If you're an ambulance provider or a lab provider or a physical therapist, those same arguments might apply. If you got advice from an outsider, you might be able to make that. It's unclear as to how well this without fault thing works in all settings, but that's definitely one of the defenses I'm going to use to get out of any overpayment situation. But the bottom line, 48 months is a pretty good limit unless you can come up with something shorter based on the facts. Okay, Last couple things I'm going to do before turning it over to Breyer for some HIPAA stuff. A refund letter. So we've come to the conclusion that we owe money back to the government. What are we going to do? First, you have to make a decision. You think you've got a big problem, and you know it's going to take you a while to quantify it. Would you ever send a placeholder letter to the government to say, "Dear government, we've discovered a potential overpayment. We're working on it"? I don't do that very often, but if I really think it's going to take a long time to figure out the numbers, I might send this letter to avoid the situation where, while we're working on the calculation, the government comes in and says, we're looking at you about this. So if I think that there's a big amount of money involved and it's going to take a little while to do this, I might actually send a letter to the government, probably to my MAC. I'm not going to send it to the U.S. attorney, but I'm going to send a letter to the MAC saying, hey, we've discovered an overpayment. We're in the process of quantifying it. Who should send that letter? Well, I personally am a fan of having that letter not come from a lawyer. I think it should be written by a lawyer, but I would send it from a compliance person or other non-ESQJD type person, because I think letters from lawyers make people more nervous. Who's the letter to? Well, I'm taking the government at their word. You know, the government thinks that they're not going after fraudulent, or they're only going after fraud and not honest mistakes. I'm not using the OIG's self-disclosure protocol. I'm not writing a letter to my local U.S. attorney. I'm writing a letter back to my MAC refunding the money. So that's invariably where I'm going to send a refund letter. How much detail do you provide? Well, now you have to tell a reason for the refund. That's required statutorily. I'm going to do as little detail as I can to tell the story, and we'll look at an example in a minute. Okay, what do you do if it's a small issue and like the cost of investigating the issue might exceed the amount of the overpayment? You think it's $3,000 or something like that. Well, I'm going to put that in my letter, and I'm going to say, look, we think this is a small amount of money, and so we haven't dotted all of our I's and crossed our T's, but we're convinced we're refunding, more than the actual overpayment, and that's why we're doing it. But now I want to talk a little bit about things you don't say. So if you think back to Dr. C, our person who had a documentation issue, here's an actual, versus similar, kind of an agglomeration of letters we've seen. So we recently discovered our physician was committing billing fraud. She wasn't documenting services properly. We inadvertently billed for the services. We did a statistically valid sample, and we've corrected the problem. I don't like anything in yellow. I avoid placeholder words like recently because people's view of recent may change, and if it's been 6 months, I don't want anyone fighting about it. It's a word that doesn't add anything, get it out of there. Was committing billing fraud? Well, that's self-evident, but it happens a lot. You never want to characterize your own behavior as fraud. I try to avoid not documenting services properly. I don't like that phrasing. I would probably say something like the documentation didn't meet the code billed. The billing wasn't inadvertent, another throwaway word, and I even try to avoid saying we've corrected the problem because all too often you in fact haven't. You've tried to. So what would I say? I would try to use words like this. First, I'm very fond of, as part of our ongoing compliance process. That's a great way to start how something was discovered. It leaves, because first of all, that's almost invariably how this stuff comes to light. I'm fond of using the phrase more appropriate because it doesn't say that the other thing was wrong. I don't want to admit something was fraudulent or improper, so I don't want to say it was improperly documented. I just say it would have been more appropriately documented another way. I like possible issues. Once again, I'm trying to avoid an admission. This next point is super important. I want to preserve the right to recant. And what do I mean by that? In some situations, I don't think a refund is required. And so I'm going to tell a war story here. Client came to me with a $300,000 issue they wanted to refund. I didn't think they needed to do it. So I said, I wouldn't do this if I were you. They said, we still want to. And I'm like, my job then is to say, okay, well, let's do it. How are we going to, let's make it work. That's first of all, the one situation where I think a lawyer should write the letter. So I had that letter come from me. And I said, the client is choosing to refund this money. I don't think that they need to. So here's the money. If you come after them for any more money, we reserve the right to appeal this voluntary disclosure. Because then what wound up happening then, the carrier got our letter and they took our $300,000 and they asserted an overpayment for an additional $800,000. They went back further. We had gone back to a clarification that was issued. They went back 8 years, which goes back more than the 4 years that was there. So we then appealed, appealing not just the time period over 4 years and not just the period over the clarification, but the whole amount, and we won. And the lesson that I think is to be learned there is don't let your good deed get you in trouble. If you choose to voluntarily refund money, there's a legal argument that you could make that you don't need to refund it, make sure you get the full benefit of that. And make it clear that if the government decides to try to get greedy, you're going to challenge your voluntarily disclosed amount. Okay, I'm fond of the phrase "level we're confident defending" because I think that's a good way of saying, it's self-evident there. Avoiding the phrase "our attorney told us," because you have to recognize any advice from an attorney that you disclose in this letter could waive the privilege, and that can make some of these letters difficult, especially the letter where you're choosing to refund and the attorney said, "I don't think you need to." You have to figure out how to finesse that without waiving privilege issues. I try to characterize things as a refund and not as an overpayment. Once again, I want to, if the government comes back and tries to argue we've committed fraud, I want to say, no, we weren't even overpaid. We're choosing to refund this money. And finally, I'll talk about steps to improve things. Now, if you send one of these letters, what's going to happen? Are you going to wind up like this? And we're having some serious lag right now on the internet is slow. Now stay calm. Let's hear what they said to Bill. For better or for worse, most of the time, our voluntary disclosures have not resulted in dramatic things like an OIG subpoena or something like that. But I've now worked on 3 cases where we voluntarily disclosed an amount and the government has come back and sought way more than we voluntarily disclosed. All right, I'm going to whip through 4 more questions or 5 more questions and turn it over to Breyer. So first question, do you ever ask the payer whether, before you refund money, do you ever pick up the phone and say, hey, do you think this is an overpayment? And that's a tough call. There are a few situations in which I do that. If you do that, you got to make sure you disclose all of the relevant facts. And I think the most important thing is if you ever get advice from any payer as to whether they're going to pay things, make sure you send them a certified letter saying this is what you told us, so that you can avoid a situation where 3 years from now they deny having given you the advice. A question that comes up a lot and that I almost wish people didn't ask me is, what do you do with copayments? The law on that point isn't entirely clear. This is why I almost wish I didn't get asked, is because I think it's really difficult to deal with them. Practically what I do with copayments is look at the size of the copayment. If the copayment amount is small enough that you wouldn't charge the patient if they owed you the same amount, I'm basically okay ignoring it. It's not the law and it isn't really very clear, but it feels consistent. And this is where I want to be consistent in how we approach things. You got to know what your state law is, but if it's a big copayment, or if you bill patients, like if you bill patients when they owe you 13 cents, I think you got to refund patients when you owe them 13 cents. Next question that comes up a lot is, do you rebill amounts of money, or do you refund them? If you discover a big issue, do you have to reprocess all of those claims? Well, this is getting to be more and more of a problem for a bunch of reasons. First, I'm seeing insurers insisting that you rebill, and their argument, and I understand this argument, is that they want to have good claims data in their system, and if you just refund money, their claims data is wrong. The problem is, if you rebill, you can run into timely filing issues, and I've actually seen one insurer say, yes, you have to rebill, and by the way, we're not waiving our timely filing claims, so all those things that are more than a year, you just have to eat those. Well, on that, that's just massively unfair, and there's no way I would ever allow an insurer to do that without going to court. So if you're going to be in a situation where you rebill, I think you do that only if you get an understanding from the insurance company that they won't deny claims for poor filing. Otherwise, I'm going to go the refund result, and I think that unless you've got a contract with the payer that prohibits that, you're okay. And with Medicare, I think that refund option does work. Your duty is to report and return. Your duty is not to report and rebill. The next really interesting question that comes up, and I skipped ahead one too far. How do these refunds affect RACs? And so this is a really interesting thing. You go through and do a sample. And as part of the sample, you refund 10% of all of your claims. Then a RAC comes in and does an audit. There's a double counting issue that can come up because you've voluntarily refunded a bunch of money. How do you deal with that? Well, it's difficult, and it's going to require help from statisticians. It's something you have to be alert to. Basically, if you've refunded money off of a statistical sample before, you got to keep in mind that in your new sample, that amount is sort of out of play already. So if you've refunded a third of all of your claims and they come in with a new sample, a third of that sample's money is gone. It's just something to keep in the back of your mind. And note that this kind of ties in with the rebill refund issue, because if you've rebilled, that problem doesn't come up, but if you've refunded, it does. Last question for me is private payers. It's all contractual, and so you got to figure out what the private payers say. Is Medicare Advantage a private payer or a public payer? I am quite convinced now, thanks to diligent work by Katie Burkhart, one of our good brains, that a Medicare Advantage plan is a private payer, not Medicare. So I don't think Medicare rules apply to Medicare Advantage. I think it's whatever the contract says with you. So when you're dealing with private payers, you got to look at the contract, you got to look at state law. I'm going to turn it over to to Briar, who's going to talk about HIPAA, and then I will come back and close with what we're going to do when investigators show up.
Okay, thanks, David, for referring to me as HIPAA. I might start going by that now. This is the part of the presentation that is not going to be interesting, so try and hold on for about 15 minutes or so, and then David will get back to his cartoons and interesting war stories, and in the meanwhile, I will talk about HIPAA and what's going on with that. So we're in a new period of HIPAA change, and is this 2.0 or 3.0? It's not really totally clear, but there's a lot of stuff that's going to be happening in the next little while, probably about a year. We are going to get new final regulations coming out eventually. We've had proposed regs sitting out there for a while, and those regulations are supposed to implement the high-tech provisions that we'll talk about. The best guess for the new final regulations is going to be late this year or early next year. And those regulations, when they do come out, are going to be a doozy. It's going to be a big omnibus regulation. It's going to include HIPAA, it's going to include breach provisions, enforcement provisions, the Genetic Information Non-Discrimination Act, and probably a few more things altogether. So be ready for that. There are, a few groups that are not really paying much attention to HIPAA still, and I think that is starting to change, and I think when the final regs come out, that will change further. But until the final regs do come out, you can focus on current compliance issues, and I think that's going to serve you well. There is going to be plenty of time to comply with the new regs. We'll talk more about the actual compliance dates later, but you will have time. So in the meanwhile, look at your policies, look at your systems. If you've done a risk assessment, that's good. If you haven't done a risk assessment, you should. And as you're doing all this stuff, as you're doing the analysis of what you have in place now, ask yourself, if the government asks why you're doing something, do you have a good explanation for why you're doing it that way? Because you don't want to be trying to answer that question in response to an OCR letter. So the biggest risks right now that we've seen with HIPAA investigations, nosy employees, people snooping into their coworkers or friends or anybody else's records, celebrities' records. We've seen an unfortunate uptick in the use of camera phones in the emergency room or operating room. Never a good idea and always surprising when people think it is okay. Angry patients are always a problem, and that is where honest mistakes can turn into investigations. If patients are mad and they submit a complaint to OCR, OCR is going to come knocking, and you'll have to explain yourself. What might have been a pretty innocuous seeming thing can turn into a big deal. Estranged spouses are a big issue there. So if, for example, your EHR is set up to link family accounts together and the patient either does or does not tell you that they have moved on and are not living with their spouse anymore, you send information to the spouse or to the named patient on the account. That can cause major problems. Another big issue is laptops and thumb drives and really paper records, backup tapes, other things getting stolen or misplaced. And that may actually be the biggest risk, because that is likely to include the most number of patients, the most sensitive information, and because there are so many, it just gets to be a very expensive thing to deal with, even if you're not fined for it. So OCR, the Office for Civil Rights, is the investigator of HIPAA issues. If they come knocking, most of the time, if you play nice with them, they will play nice as well, and these investigations generally are not too bad. What usually happens is OCR will send you a letter saying, we've got this complaint, please explain yourself. You explain yourself and hopefully tell people why, tell OCR why what happened, why it wasn't a violation, or if it was, what you've done about it to fix it. They can be really bad investigators that come and try and figure out what's going on, and they can cause problems. They can ask to see everything that you've ever done related to HIPAA, ask you to change your policies, ask you to do lots and lots of things. They can do on-site visits. They can make life miserable even if they are not fining you for anything. And, in fact, there has been a fine issued, and it was a huge one. So some people out there are saying this is a sign of HIPAA's new enforcement and the government's getting really serious. There was a civil monetary penalty of $1.3 million, but truly the sole lesson to be learned from that fine is don't be an idiot when you're dealing with the government. This was a company called Signet Health, and their initial problem was that they denied patients access to their records. So 41 patients didn't get access to their medical records, and those 41 patients all filed complaints. So the government investigated this, as they do, and instead of responding to the request for information, Signet did not respond at all. They didn't respond to a subpoena. They ignored virtually every communication from the government. So clearly that was making them mad. Then, when they did eventually produce all the records in response to a federal court order, they didn't just produce the records of the 41 patients in question, they produced records of 4,500 patients, 59 boxes worth, and delivered them to OCR. The 4,500 patients' records were not part of the investigation, so they just were flouting the government at every turn. So that resulted in this $1.3 million civil monetary penalty, which was for the actual not giving patients access to the records, and then a $3 million extra fine for willful neglect. So don't worry about this $4.3 million fine. It's extremely unusual, and most fines are smaller, and civil monetary penalties are still extremely rare. So cooperation is still going to be the name of the game, even with the new regulations, which we'll talk about. The regulations say you must cooperate with the secretary when they come knocking. You must permit access to records during your regular business hours. But the good news is that they still are going to try to resolve these issues by informal means if possible. And we'll talk more about that in the enforcement section. But generally, it's a letter, a response, a follow-up, and then often a very belated confirmation that everything is wrapped up. So do defend yourself if it's not a violation, or if it's borderline, say why. And if it's a technical violation, note that there's a lack of harm if it's true, and describe your detailed corrective actions if you can. It's better if you've taken corrective actions before the government comes knocking, so if you get a patient complaint or if you get employee concerns, try to address those right away so that when the government asks you what you're doing about it, you can tell them and look pretty good. So the new stuff that is out there, the high-tech is the statutory provisions that affect HIPAA. There are new proposed regulations to implement those, and there may be a phase 2 of high-tech rules that deal with electronic records and health information exchanges. This is all going to shake out over the next year or so. Investigations will presumably be and there will be increased enforcement, and during that time I think things will just kind of continue as usual until we have final regulations. So don't be really concerned with the new stuff as much as making sure you're compliant with the current stuff. The high-tech changes, I've just outlined them here, and we'll talk a little bit in a little bit of detail about a few of them, but I don't want to get too far into it because of these proposed regs that are out there. Generally, all of these high-tech changes are going to be effective 180 days after the compliance date. So we're waiting for the proposed regs, and then you're generally going to have 180 days, although in some cases more. So in the next few slides, I've included some high-tech HIPAA stuff. Again, we're not going to get too much into them, but business associates are an issue that there are going to be changes, but there are issues that you can deal with right now. Business associates are going to be directly subject to the privacy and security rule, and in fact, they are right now, but there's not going to be any enforcement until we get some finalized rules, according to the government. Certain provisions of the security rule are extended directly to business associates, so administrative, physical, and technical safeguards, they're required to have those. The privacy rule gets partially extended to business associates, and generally that means that the elements of the business associate agreement, those required elements, are going to be legally applicable to business associates. And if a business associate screws up and does something that's not permitted by the contract, they'll generally have violated the law as well. Breach notification requirements, business associates now have a requirement to notify their covered entities. I would add specific breach notification provisions to your business associate agreements, and I would probably go ahead and do that now. The high-tech, the privacy and security requirements are supposed to be incorporated into the business associate agreements, but how they're supposed to be incorporated is not clear, and that's what we need to wait on a little bit. The one thing I would say, if you're doing any changes with your business associate agreements now, and you could do it now, you could wait, but I would consider right now getting indemnification provisions into your business associate agreements. The costs related to breaches can be very, very large, and that's cost of credit monitoring, possibly internet reputation monitoring, but staff time, lawyer time, the data analysis that you might have to do if it's, for example, a stolen laptop, that all can add up into the hundreds of thousands of dollars pretty quickly. And if it's something that your business associate has screwed up, there's no reason that the covered entity should be on the hook for that. So breaches, the breach regulations are separate from high tech, but I wanted to include them because of their relevance with business associates. There's an interim final regulation that is in place now. It's effective. HHS had a final rule ready to go, but they pulled that from the OMB supposedly for non-substantive reasons, but that's unclear exactly. So right now you can deal with the interim final reg, which requires you to notify each individual whose PHI has been or is reasonably believed to have been accessed, acquired, or disclosed due to a breach. And I've got a little star by, sorry, I'm a little bit behind. I've got a star by unsecured PHI because we're going to define that in a few slides. The definition of breach is, as I said, the acquisition, use, or access that's not permitted. But the second point there is the most important. It must pose a significant risk of financial, reputational, or other harm to the individual. So that's key. It's going to require careful analysis. Definitely when sensitive info is involved or social security numbers, you're very likely to have a breach. But there are close calls in lots of other cases, so that's going to require you to take a look at really what information was out there and whether it's truly going to be a risk to the individual. There are a few definitionally accepted things. These are not breaches. I won't go into detail about those because they're really rare. But of course, you want to look and do the analysis above to see if it's a significant risk. Notification to the individual has to be done without unreasonable delay, but no later than 60 days. And here again, you need to be careful about what your business associate agreements say about breach notification. Because if you make the business associate if you let them have the full 60-day period to report, you're going to have no time to do anything about it later. So some business associates will insist on having 60 days or 30 days to tell you about a breach. I would prefer 1 to 5 days of a suspected breach. So don't let them go through the whole analysis and come up with when they think they should tell you. Make them tell you if there's any question about whether it's a breach, and then you can go ahead and do your own analysis. You're deemed to have knowledge of a breach if a workforce member knows about it. So make sure your employees know how to report and that they need to report, and implement some kind of penalties if they don't. If they fail to report, you are going to be on the hook for that failure. The notification requirements in the breach notification rule require that if there are more than 500 people, you have to notify prominent media outlets that are serving your state or jurisdiction. Also, if you hit that 500 threshold, the government has to be notified immediately when the individuals are notified. The government does get notification of everything, but it's a lot better if you can just do it in your annual summary rather than notifying them right away. Unsecured PHI, this is the stuff that has to be if you lose this type of information, that's when you have to do that breach analysis. If it's secured, that means you've encrypted it or destroyed it. But otherwise, if you've got usable, readable, or decipherable information, then you've got a potential breach situation. So you don't have to encrypt and you don't have to destroy, but if you don't, you cause a little bit of risk for yourself. And I want to highlight, too, the destruction piece of unsecured PHI, because we have seen a couple of pretty big dollar penalties for failure to destroy information properly. So you want to make sure that you have, if it's paper or a hard version of this, you've shredded it or destroyed it so that information can't be read or reconstructed. And otherwise, if it's electronic, you want to clear it according to the guidelines for media sanitation. Back now to some of the high-tech provisions. There are new restrictions on disclosures. A patient can tell you that they do not want their information given to a health plan for payment or healthcare operations purposes, and you have to agree to that if the person has paid out of pocket in full. Under the old rule, the patient could request restrictions, but you didn't have to agree. Now you have to agree if it's for this specific case. And it's more complicated than it looks, because plans get information for more than just payment purposes. If they're doing an audit or a quality review, you have to be able to have that patient's information flagged and not disclosed. The high-tech statute also changed the limited data set and minimum necessary requirements, but it is so convoluted that I'm not going to go into it much. I would only say there that you need to just be careful about what you're sending and using. Make sure you're using as little information as possible if you're sending something to a business associate or really to anyone for non-treatment purposes. You want to give them the minimum information necessary for them to be able to do their job. And related to that, try and make sure you've done a review of what job categories are entitled to what type of information, how much information they can get. We have seen OCR ask that question in several investigations, and most organizations haven't done the best job of saying who gets access to what. So do that, and then you're in better shape for the limited data set and minimum necessary requirements. Accounting for disclosures. The new law removes an exception for accounting for disclosures that are made for treatment, payment, and healthcare operations purposes if that disclosure is made through an electronic health record. So there is a lot of worry about this. And again, we are going to have to wait for the new regulations to be finalized before we can know exactly how worried we should be about it. But what the proposed regulations have done is say that you need to be able to produce an access trail, basically, for anybody that has accessed the information, even if it's for treatment, payment, and healthcare operations purposes, as long as that access was done through an electronic health record. I think that most people think it's going to be a lot harder to comply with this than the government appears to think it will be. And it's unclear if any patient actually wants to have a giant pile of an audit trail or if they want some more refined information. So again, we'll wait to see how that shakes out, but that's on the horizon. In the meantime, check what you can do now with an audit trail. If you have an EHR, figure out if you can use that appropriately to see who has looked at somebody's records. Prohibition on the sale of PHI, that and this, the marketing provisions that we'll discuss in a minute are also an attempt by the government to sort of fix a perceived loophole. It's not totally clear that it was necessary, but they're trying to fix that. So that is out there. The marketing provisions have always been strange. A lot of marketing is actually treatment, and now there are attempts to fix this loophole, but the new regs are going to be key because the statutory provisions related to this are really kind of a mess. Restrictions on fundraising. Again, we're just going to skim through that. You can read the slide. Getting to enforcement, high-tech does expand liability for criminal violations. It also requires a formal investigation by the government of any complaint where the preliminary investigation shows a potential violation due to willful neglect. And they're required to impose a civil monetary penalty where a violation is found in those cases. The proposed regs to the preamble does say that the Secretary will often seek to correct noncompliance through voluntary corrective action, so that's out there. And that is still good, but again, we're going to have to see how that shakes out. Criminal penalties, again, we'll have to look to the final rules. The new tiers of penalties that are out there, there's going to be more discussion of that in the final rule. Definitions themselves are discussed in the preamble to the proposed rule. One thing that concerns me is that willful neglect supposedly includes actual or constructive knowledge of violations, along with the failure to implement or develop compliant policies or procedures to respond to incidents. So this is a case, again, where you want to review what you've got out there for your compliance purposes. And then I think we're just going to skip to my last slide before David freaks out because I don't let him finish up his slides, just to talk about the settlements a little bit that we've seen out there. Signet was the first and, to my knowledge, the only civil monetary penalty, but there have been these settlements that the government has gotten from a bunch of high-profile situations. UCLA was an investigation where celebrity patients had their medical records reviewed. Mass General is the one that I am most concerned about. This was a $1 million fine for records that were left on the subway. They were not electronic, they were just paper records sitting out there. But in my view, there was pretty limited protected health information. It was a patient schedule with names and medical record numbers, and then for 66 of these patients, there was a billing encounter form with a name, date of birth, a medical record number, insurer and policy, and diagnosis, along with names of provider. That was only 66 patients, but the key thing here, I think, is that was HIV/AIDS information, and I think that's what really kicked the government up to make this a big fine. But $1 million is $5,000 per patient, so we are hoping that this is not kind of the bar that's been set and that there's not a $500 fine every time there is a violation per patient. So with that, I'm going to turn it back over to David, and sorry for breezing through so many slides.
Yeah, but who isn't guilty of that, as I have thousands of them. So part of it, so why is HIPAA in this interacting with the government thing? I have never had a government investigator spend 3 consecutive days on site as part of a government investigation until August of this year, when a HIPAA investigator spent 3 days on site dealing with a breach where an employee, where the allegation is a physician accessed an employee's medical record to figure out whether the employee was a malingerer. So just something to put in the back of your mind. All right, I'm going to close with kind of prepping for the agents actually showing up. You know, here are the agencies that can darken your door, and the scariest, of course, is the postal inspector, employees of the U.S. Postal Service authorized to carry a firearm. But any of these agencies can make your life pretty miserable, and you need to get people ready for it. Everyone needs to understand, if you get a letter from the government, you know, this is kind of what Breyer is talking about. If you ignore stuff from the government, bad things happen. And making sure people are reading bulletins and things like that. But one often overlooked stuff is what the routine audit, which, you know, there's no such thing as a routine audit, or the routine survey. So this letter went out, this is old, this was like from 1995. If you look in the upper left, what looks like a football helmet is actually the eagle from the Health and Human Services. In this semi-friendly sounding letter, you know, we're just conducting an audit of payments for lab services. We need your assistance to verify that the services were provided and billed. If you go through the next, you know, it looks like a little survey. Did you order a complete blood count? Did you specifically request stuff? It's the sort of stuff people can check boxes on fairly easily. And we skip ahead to the end. When the background for this was lab stuff, where salespeople were, automated hemogram indices were these new things that lab machines did. The lab machines did them pretty well. And so the question was, were they covered? And so the question was, did the lab tell the doctor that these things were billed? And the answer was, in many cases, even if physician-owned labs, they didn't know. Skip to the last question, 4E. Were these indices useful to you in the treatment of a patient? And many of the doctors that I worked with on this, and I worked with like a dozen, didn't even know how to read these things, but the salespeople had told them that this machine was really cool and did this neat stuff, and so they were billing for them. They didn't know how to read them. When they checked, were these indices useful to you in the treatment of the patient? If they checked no, does that make the claim a false claim? I think there's an argument yes. Now, I can make the argument no, and my answer of no is that it's when the person ordered it, they thought it would be useful. This question is kind of in hindsight. Now, do you think they were useful to you? And I think the test for medical necessity is when you ordered it, did you think it would be useful? But people were, in my mind, checking out a survey, filling it out, and sending back possible admissions of false claims. And part of the reason I include that in this talk is what happened operationally. In many places, the receptionist who opens the mail filled this thing out because they thought that was his or her job, was to be helpful. In some cases, it went to the doctor, but the doctor didn't go talk to anyone and say, and what was going on because they were embarrassed. Sometimes it got to the administrator, but the administrator didn't get legal involved. That was complicated and expensive. And what's really going on here is they don't recognize the significance of this. It's the open the gate, it's a big wiener dog. And so one of the things you got to do is make sure your people recognize that anything that's going back to a payer or the government really should probably be going past legal, or at least someone in the compliance office, someone who's going to really think about whether this is a big deal or not. A survey from the government or from an insurance company can get you into a world of hurt. And so that's kind of a proactive step you can do now to minimize your interactions with the government, is get people on board with that. Related to that, you've got to have your employees ready to know what to do if someone shows up at the door. And remember that when you train them, the half-life on this stuff is super, super short. You can tell them not to talk to the government, and when someone shows up, they're still going to talk to them. But you want to have everyone in possession of phone numbers that they know if someone shows up at their door at 5 o'clock on a Sunday or 7 o'clock on a Thursday night, who they're going to call. And every employee in your organization should have that ability, and you want to have the ability to reach out to your employees in a hurry, because it may be Thursday night and the people in your research department are getting visited, and you want to be able to call all of the other ones in a hurry and get a hold of them. Next prep thing. This is a disturbing true story. So orthopedic surgeon calls me one day and says, David, I need you to help me out. I just got this subpoena for some malpractice case, and I'm out of town that day. Can you take care of it? So they fax me the subpoena, and I read it, and it turns out that it wasn't a malpractice case. It's a grand jury subpoena from Atlanta. And it says, the United States Attorney requests you don't disclose the existence of this subpoena. Any such disclosure would impede the investigation being conducted and thereby interfere with the enforcement of the law. This is where I got really lucky. My client didn't read the thing very closely, so he didn't see this. But part of your prep work for people has to be to get everyone in the organization to know that if someone in the government ever tells them, don't tell anyone that you were contacted, they can tell you as legal counsel they were contacted. I actually think it's unethical for the U.S. Attorney in Atlanta to include this statement in there. But you need to do is prep work to get people, it's really hard, because if the government says you can't tell anyone, even if you've done the best prep work in the world, it's going to be hard for people to believe it. One of my colleagues sent around today a really disturbing case where the government was contacting represented employees and taking the position that Rule 4.2 didn't apply to the government, something which I thought we'd answered a few years ago, and a judge basically agreed. So we seem to be entering another phase where the government is going to try to contact employees, do it, and say, oh, you are not going to work through legal counsel, and we can tell the employee they can't tell legal counsel. And so we've got our work cut out for us here to get people aware of this ahead of time. When you get a letter from the government, things are a lot easier to deal with because you have time. But one of the training things that we can all do ahead of time is make sure employees know that if they ever get a letter from the government, keep the envelope. A disproportionate share of the communications we get from Max, especially, I have the most extreme example was a letter dated July 17th and postmarked September 22nd. Yes, over 2 months later. So one of the tough things is you can't, if you get the letter a day later, it may be too late. The envelope has been recycled. So good preventive risk management, make sure everyone knows if they get a letter with a bird on it, they need to keep the envelope. And they should be date stamping everything with a received by. Another thing to keep in mind, you may have insurance that covers any government investigation. A lot of malpractice things have riders for it right now. So anytime any investigation comes up, think about whether you have insurance, either specially purchased insurance or a rider through something else. Okay, last thing we're going to do is what to do when the agents actually show up. If they show up on site, you want to make sure that you know what they see. Worked with a client in New Mexico where the auditors absconded with a bunch of original documents. That was no good. So you want to make sure that you've got a control over any original records that the auditors have. Keep the auditor isolated from the rest of the business if you can. It's okay to be friendly but firm with those guys and make sure you've got copies. If they can work off of copies, that's way better if possible. If they call, one of the other things to train folks on is don't trust that someone who represents that they're from the government really is. Ask them to get the person's name, jot that down, ask what they're calling about, and tell them they'll get back to them. We've twice had people pretend to be government agents that weren't. Also, you don't really want anyone dealing with these things on a spur-of-the-moment thing anyway, so getting their information gives them time to get the information, take a breath, and call them back. If agents show up at the door, if they have a warrant, they're going to get free reins of things. But if they don't have a warrant, basically, they can come in, you don't have to talk to them. You can be polite, but there's no duty to do anything. Even the Medicare requirement that you give immediate access to records, immediate access is defined as within 24 hours. So absent a warrant, an agent doesn't have the right to walk out with anything. Ask for their ID and get on the horn. If you, in most cases on this call, you are legal. The government is going to try to say that it's okay, you don't have to worry about this. It's kind of one of my favorite lines. Oh, this isn't a big deal. Yeah, an agent has driven 200 miles to go to Springfield, Illinois from Chicago, but it isn't a big deal. They do this all the time. The agents are really good at sitting quietly and getting people to blurt things like, are you here because of the? And so, a big part of the training is getting people to understand that they don't have to talk to the government and that even though silence is awkward, it's the way to go. It's also training them not to say, oh, our lawyer said this was okay, because when someone in Michigan did that, a court ultimately ruled that was waiver of the privilege. So there's a lot of preventive risk management training to do, and I would do this as part of, at the end of your compliance training, have a 5-minute blurb on how to interact with the government that's something like this. The government's going to do the, okay, I'll go back and tell my people you're not staying in the boat. I warn you, they're not going to like it. And it's very effective with especially physicians. If you don't talk to me, the government is going to be mad at you. Physicians don't want to have people mad at them, and so they will often talk under this pressure. And it's getting people to understand that the choice is stay in the boat and have mad sharks, or jump in the water and have happy sharks. I'll take the mad sharks. The agents don't believe that there are innocent mistakes, and it's getting people to know that. Last 2 slides. Agents can't make anyone talk with the exception of agents who work for the boards of licensing who generally can require people to cooperate. And so that's part of the training. You got to get people to understand that licensing boards are different, but they don't, even the licensing boards, you have a right to have counsel with you. The government can't get documents without a warrant or a subpoena. They can't get privilege information, and that's a point we've already mentioned before, but boy, I really want to harp on it. The government can't prevent someone from talking about the interaction. As an organization, we can't prevent our employees from talking to the government, so you can't have a policy of don't talk to the government. What I always tell people is, you have a right to talk to the government. I discourage you from doing it. And I try to make sure all employees know that if a government agent contacts them, legal counsel will be covered by the company. They don't have to worry about that. Get a hold of legal. We'll get a lawyer for you. They'll be representing you, but we'll pay for it, as long as we coordinate that. And that's important because otherwise they'll contact their friend Fred the lawyer, and so you want to make sure that they do that through you. Obviously, making sure employees know that they can't lie to the government, that kind of goes without saying, and not to destroy or hide documents. Now, Breyer had to scurry off for a call, and she's the HIPAA guru, but if there are any questions, you can fire them off. This one really didn't invite, I think, questions in the same way a lot of the other ones did, and I don't think that they've poured in. But I'm happy to take questions. Otherwise, I will note the next webinar is going to be on relationships, and it's going to come up with interesting ideas for joint ventures, for acquisitions, and the like. If you've got questions about any of this stuff, you're always welcome to email us. And I guess my closing thought will be, I think we're in for a rough government ride. I think both on HIPAA and on audits and investigations, the government is really using this as a mechanism to shake organizations down. And philosophically, my request to everyone on this call is lock your doors. Don't let the government take money from you, unless you've really done something wrong. I don't think the government will break many windows. I know in my experience, when I've got a client that's got strong defenses to make, and we've made them, the result has been the client hasn't paid money in situations where other people have paid a boatload. Sometimes other organizations have paid in the 7 or 8 figures, and our client has said, no, we're not paying. and the government hasn't broken the window. Instead, they've moved on. So that's my closing words to you before I look at the one question coming in is, please lock your doors. And actually, you know what? I'll just follow up with that person one-on-one. And if thanks for logging in. Please fill out your evaluations, and we hope to see you on November 9th.